My first part I'd like to do is to introduce our chair. Hillary Finley is a recently retired member of the Department of Sport Management and an absolutely wonderful colleague. It's been an absolute pleasure to work with Hillary within the legal field and stream here at Brock and Sport Management, and it's been absolutely fantastic. She's been an absolutely fantastic legal scholar in the field and in practice. So we appreciate Hillary's leadership of this particular panel and her leadership in sport law at Brock University. In terms of being a Canadian sport lawyer, advocate, teacher, and researcher, Hillary's work focused on athlete participatory rights and obligations and regulation in sport, including organizational fairness, responsibility, and the provision of the safe sport environment. Dr. Hillary Finley brings with her a wealth of experience in research and practice to this legal session. And without further ado, I'm going to hand it over to Dr. Finley.
Thanks very much, Mike. Well, welcome to panel number 3 of this forum. The focus of this panel is on legal issues that arise in pursuing a safe sport agenda. We're going to take a fairly broad approach to this topic, addressing both some specific legal issues and looking at broader proactive approaches to being an inclusive and safe sport environment. We start with the joint and mutually engaging proposition that athletes, indeed all participants in sport, can expect to participate in an environment free from abuse, harassment, bullying, discrimination, all known as maltreatment. This is one of the fundamental tenets of the newly adopted Universal Code of Conduct. The other side of this proposition is that sport organizations and those involved in the delivery of sport have a legal responsibility to ensure an environment free from maltreatment. It's a big collective responsibility, and it is here where some of the legal challenges lie. We were also reminded in this morning's session that sport operates in a number of spheres at the same time. We have to be mindful of both the societal, legal, and cultural context, as well as the sport-specific legal and cultural context organizations operate in. So we're going to try to combine both of those contexts and both the legal and the cultural context a bit this afternoon. So before introducing our panelists, there are a couple of housekeeping comments. I think Mike covered some of them, but just to reiterate, it never hurts. Mics and cameras, if you wouldn't mind keeping them off so that the spotlight is on the panelists. And just a reminder that this panel session is being recorded and will be available to you shortly after the forum. And as you've heard numerous times before, there's an opportunity after this session for breakout discussions, and you simply click on the appropriate breakout room to the left side menu. Fourth, as the panel session progresses, we welcome questions through the chat function. I'll be trying to monitor them as best I can and pull questions out on various themes as we move along. And the panelists as well have their chat functions on, and to the extent that we're able to multitask here, we'll try to pull them out and answer them for you. But if we're not able to, we will be taking note of them and try to respond after the forum. And finally, feel free to keep up a broader social media conversation using the hashtag CSC Safe Sport moniker. So very quickly, let me reintroduce the panel to you. We have with us 2 lawyers and a diversity expert. We have Dasha Pergadova, who is a lawyer with the Toronto firm Aird & Burles. Dasha is the past president of Athletes Can and has been very much engaged in this whole process, culminating in the introduction of the Universal Code and the independent mechanism. She continues to work with Athletes Can, advocating for athletes' rights. Dasha has recently been appointed as the ombudsperson for Team Canada for the upcoming Tokyo Olympic Games. We have with us Bobby Sahani. who is a co-founder and partner at Ethnicity Matters, a leading authority on multicultural marketing and communications. He's worked with an array of sport organizations, both professional and other, exploring diversity issues. Bobby has recently been appointed to the board of directors of Hockey Canada. And our third panelist is Kate Scallion, who is a lawyer with the Victoria firm of Jones, Emery, Hargreaves, and Swan. Kate is actively engaged in the representation of athletes on safe sport matters and writes on issues relevant to sport, including gender equity, safe sport, and anti-doping. More detailed profiles on each of our panelists can be found at the Athlete Forum material in the Center for Sport Capacity website. Right, so in terms of the format for today's panel, we have a series of questions that we are going to use as a basis for an interactive conversation by the panel. And as I mentioned before, I'm going to try to insert your questions as well into the conversation as we move along through our discussion. So we'll start then with some general questions and then lead into some more specific ones. So here's my question to all of you. And perhaps each of you can take a few moments to discuss your perspective of the challenges of creating and sustaining a safe sport environment. Why don't we start with Dasha?
Thanks, Hilary, and thanks for the introduction. That is a big question. So thanks for putting me in the hot seat first. And I won't be as warmed up as some of our colleagues that have spoken earlier today. And I know there's been a really productive discussion already happening for a little bit of a day and a half. So it's really nice to hear some of the comments and questions that have come out of that. I mean, some of the challenges. First of all, this came up during one of the conversations that we had with this panel offline earlier, but that's, beyond the sport context, I think the concepts that we're starting to discuss within sport itself, like maltreatment, like neglect, like harassment, those concepts, it's not that they are well established beyond the realms of sport either. They might be better established in, workplaces or some other context, but it's not like we don't have challenges with the enforceability or the consistency or the eradication of that kind of treatment in other contexts as well. So it's not that sport is just looking around and saying, okay, how can we best adapt these practices and use them as a springboard. I think we're actively seeing an evolution of our general understanding of those kinds of concepts, and we're simply applying them to sport. And then add to that a very challenging environment where competition, intensity, like the UCCMS addresses, differences even between sports, add to that the layer of all of those things, and you have a very complicated environment within which to apply those concepts in general. So in terms of the gradual build, I think we're doing our best, but that is the reality. I would say that one challenge is resources in administration. Certainly, I think there's a lot of organizations and individuals alike who want to do right by these things, who want to see improvement, and certainly a lot of the issues that the term safe sport covers are not new issues. They've been around for a very long time. But there is a real resource gap with some organizations and also an inconsistency with the amount of resources across the spectrum. And so you have some organizations that are well advanced and maybe even have the capacity to hire staff to focus specifically on these issues, and other small organizations that are really just trying to keep up and do their best. So that results in a very reactive environment, rather a preventative and a proactive environment where we get ahead of these issues as opposed to just trying to respond to them once they already happen. So those are two maybe comments I'll make initially, and I'll pass it on to my colleagues to make some other remarks.
Thanks, Dasha. I think we probably will engage in some of those points a little bit later on. Bobby, perhaps your perspective.
Sure. Thanks for having me here today. Firstly, full disclaimer for everyone: I'm not a lawyer, and I'm not an expert in sport by any mean. I absolutely happen to be on the board of Hockey Canada, but what I am an expert in is helping organizations understand really what the demographic shift in Canada means for organizations and ultimately the country. My view, first and foremost, is that Canada is a very unique country. There is no country like this on the planet. If you look at this country, we've obviously got our rich Indigenous history that needs to be understood. We've got a very unique Francophone culture. We've got our own Black history as a country, and we're arguably one of the most multicultural countries on the planet as well, given our influx of immigrants and international students that come to this country every single year. So with all of those factors, that the diversity in Canada is real, and then we can layer on so many other elements, whether it's gender expression or abilities or age or religion. Canada can be complicated if we try and figure out people. Now, if we apply that, the way I look at it is, and I'll speak from the frame of reference of immigration, because that's where I spend a lot of my time and focus. As immigrants come to this country, they're bringing with them habits, attitudes, and norms from back home that are shaping our country as well. And these are things that need to be understood. And if I apply that to sport, there are implications absolutely for athletes, coaches, even parents, to understand how to actually thrive in such a diverse society. In such a diverse country as well. Won't get into the specifics of what that means, but I can tell you, one of the terms that I often use is cultural baggage. We have to understand that cultural baggage that comes with that shifting demographics and essentially what that means for Canadians and anyone participating in sport in any way. So that's a high level overview of kind of the shift of what's happening and what that means for organizations, and definitely a lot of crossroads and things to think about when we discuss the topic of maltreatment.
Thanks, Bobby. It's a very important perspective, because that's a societal perspective that is imported into the sport environment, as well as the pressures of sport that Dasha was talking about. Kate, perhaps you can add into this.
Thank you, and thanks. It's a privilege to be here. I'd say, speaking broadly, the two big challenges that immediately come to mind are uniformity. So having a code that can be adopted across the entire sport spectrum, and then also allowing that uniformity to permit for differences, cultural differences between how sport is practiced, because as has been discussed, it can be challenging to have a code that does embody safe sport kind of to the nth degree without being overly restrictive in terms of how sport can be practiced or how people can participate. The other big challenge is always going to be adoption and how it gets adopted, at the national level, provincial level, regional level, and then also, for the sports that kind of don't fall under the PSO or the NSO model, for example, like university sports, and then also some of the league sports. So trying to get universal adoption and then also a uniform code that allows, I guess, similar to like a human rights code, allows for differences to be accommodated.
Those are challenges, Kate, that were raised in this morning's session, and I think we'll get into them a little bit more. They really are dominant, not so much problems, but challenges, as we say. Kate, the whole notion of abuse, harassment, bullying, discrimination doesn't always present as a single event, and in fact, the panel yesterday alluded to this. Can you talk a bit about what it can look like and the impact on the individual, and how those involved in the identification of such contact needs to approach it? And just to add on one more thing to that list, how far back can one go in raising an issue of maltreatment?
That's a big question. So if I forget to answer any elements, please remind me. In terms of how far back one can go, I think it would first depend on if there's a limitation period in whatever code of conduct or discipline and complaints policy that's being followed. I don't think it's unusual for there not to be a limitation period. And I think you also have to look back at what form of maltreatment is being alleged. And if it is something like emotional abuse, I think it's necessary to look at the context of the whole relationship between the complainant and the respondent, say coach and athlete. So for example, if you have a coaching relationship that began 5 years ago and shortly therein a pattern of disrespectful communication began, I don't think it would be inappropriate for the complainant to give examples of communication dating back 5 or 6 years, even if one of the respondents' arguments in response to the complaint is that, well, this complaint wasn't timely and you should have made these complaints, when the communication happened. And I think probably one of this morning's panelists, Gretchen Kerr, would be significantly more qualified to speak on this than me in terms of looking at the emotional abuse in the coach-athlete relationship. But I think the definition of maltreatment needs to be broad enough to recognize that these aren't quite often, they're not single isolated experiences. And I think the code also needs to recognize, and this is probably going into the criminal law context where work has been done in terms of like why sexual assault survivors don't come forward immediately and why that is entirely acceptable.
And if the other panelists wish to jump in at any point in time, please do, to elaborate or a different perspective. Don't hesitate to jump in. I want to talk a little bit about social media because it's providing an outlet for mass publication and sharing of racist views and abuse and harassment and bullying. And sport and recreation are major targets within which this activity festers and continues to increase unabated. Some people are so hurt, in fact, by the abuse that they leave sport entirely. Do sport organizations have a responsibility to deal with this? And what can they do to protect the athletes? And maybe I'll ask Bobby to start on this one, the social media aspect of it all.
Yeah, I mean, I think social media has obviously changed the way people communicate, for better and for worse in so many instances. We have so many an uptick in cases of depression amongst children and whatnot, online bullying, and obviously it has its effects on sport as well. I think from a macro perspective, I think sport organizations do have the responsibility to ensure that their athletes, their coaches, families participating are going in with eyes wide open, and really, I think being educated on what they could potentially expect and how they can potentially protect themselves as well. I remember, this is going back many years ago when I was working at Rogers, and this was pre big boom of social media, and we had Sam Mitchell, the former coach of the Toronto Raptors, that was speaking to us about leadership and management, and he brought up, and I'll never forget what he said. He said, when you all do a bad job, at work, that stays between you and your boss. He said, when I do a bad job, the whole city is talking about it, the whole country is talking about it, and I have to learn to deal with it. So I remember that, and I would apply that to with this stage that we're at with how accessible and how quick people can share thoughts and opinions via the internet, via social media. And I think what's important is to have people prepared. and whether it's policy around athletes or coaches engaging in social media conversations, but also just almost a preparation of what to expect, good and bad, and potentially how to deal with it. I haven't necessarily been in a situation where I've faced any of this, but obviously working with corporations on what social media means just to communication and for their businesses, preparation and training is absolutely key for that.
Thanks, Bobby. Dasha, have you got something to add there?
Yes, I'm passively aggressively taking myself off mute, hoping you'll notice, Hillary. That's the only way. Well, first, it just anecdotally, what you said, Bobby, totally reminded me. I did a brief stint as a legal intern at the NBA, and we had a presentation by the vice president who was in charge of all the referees, and he said we get about 40 calls after a game each morning complaining about all the bad refereeing, and never once in my career did somebody make a call and say, that refereeing was really great last night. You guys made some good calls. It totally reminded me of what you were saying about Sam. But in all seriousness, I think it's really interesting. And Hillary, I think your question is interesting about protecting athletes, because in my humble experience, and with the utmost of respect to everybody here today, my experience of this issue is much more oriented around how organizations try to protect themselves from anything that might be being posted on social media, including by athletes who may have actually experienced these issues. And in my more direct line of work in labor and employment, by employees who have experienced these issues, and organizations trying to shield themselves from, first of all, embarrassment, but also added liability. And the first question to me by many organizations in sport and outside is often, is this defamation? Can I, is there any action I can take against this individual who's saying I was harassed, or I was abused, or I was mistreated? And so I find that's much more often the angle. So I hope actually that the way that you phrase your question is the direction in which it will move, as a kind of more mutual dialogue about protecting everybody, including shielding athletes from the negative effects of social media and everything that comes with the heaviness of that. I mean, it's interesting because it's such an immediate forum, and before, the way we dealt with these issues might have been, first of all, more private, and the circle of knowledge would have been much smaller, or those involved, but that was also used in the wrong way, right? That was also used as a shield, because the less people that know, the less we have to face these issues, and the less we have to sort of see the light. And so maybe the pendulum is overswinging, in the sense that I think sometimes, we do see frivolous allegations and statements being made on both sides of the aisle on social media, but it is a necessary overswing in terms of sometimes that is the degree to which someone has to go in order to see something change, right? Like the court of public opinion has had a pretty significant impact on some of the most significant changes we've seen, and many of them have been necessary and positive. So it's a very interesting point.
If I can just jump in and add one thing too, Dasha, to what you were saying about organizations protecting themselves. It's interesting because I've recently read an athlete agreement where the athlete can be penalized for basically saying anything that could be reasonably interpreted as detrimental to the reputation of the organization, which really is a very effective silencing tool if anyone was going to make any allegation in terms of a safe sport claim.
Yeah, absolutely. And it's interesting because the consequences for breaching a policy, I think, for an athlete in relation to their NSO, for example, are much more severe than if you took this into like the civil law context, where really, okay, you breached a policy, you might face a disciplinary action, but ultimately in a court of law, I mean, unless that statement was explicitly false, the consequences wouldn't nearly be as severe. So yeah, there is the power imbalance that's certainly being leveraged. I tend to think, and this is similar to the advice that I give my clients in the workplace sphere, is that the best kind of approach to these issues is really one that's much more collaborative and productive. You can have a policy in place, but you might want to say in that policy, rather than writing it as you can't, you shouldn't, don't do this or else, it might be worth it to have some more collaborative language, like, we understand that issues arise in the context of these relationships. If you feel that something has happened, or if you feel that you want to, express to us that something has occurred, we encourage you to come speak to us, and perhaps, there's a dialogue to be had. In some instances, I mean, I've never had this happen totally off the top of my head, but in some instances, maybe even a mutual statement could be appropriate, where, for example, an organization is dealing with a delinquent coach and that athlete has an issue with a coach, but the organization is having to manage and be sort of in the middle of those parties. So it really could work, I think, more proactively and collaboratively than it sometimes does now.
Thanks very much. Just a quick word. I seem to be freezing every once in a while, but you just continue talking, not a problem, and I'll catch up with you. But I wanted to ask a question around the 2019 survey that was done through, and Gretchen Kerr talked about it this morning at length and provided some of the information, as well as the athletes on yesterday. What was interesting about that was that only about 15% of the athletes felt comfortable coming forward to report maltreatment or abusive or harassing or discriminatory behavior. So that suggests that there's an even bigger issue than perhaps we thought on the surface. So does this represent a greater liability to the organizations, and how do organizations deal with the fact that this seems to be an almost underground thing? People just aren't comfortable coming forward. Bobby, do you want to make a comment?
Again, the only comment that I would make on that is, again, I'm gonna wear the diversity hat, but I can speak to, obviously there's all different forms of maltreatment. I think when it comes to something like, whether it's racism as an example, or something that is, tied to one's ethnicity or religious practice, imagine being the only one in the room and not having the comfort or the opportunity to speak to someone openly that can relate to you, quite frankly. So I'm speaking now, more personally than professionally. I know what it's like to be in those type of situations where you may be feeling a particular way, or you may have heard a particular comment or treated in a way that doesn't sit well with you, and it might be based, again, like I said, religious practice, ethnicity, whatever it might be. But because you're the only one that might be going through this, you just find it difficult to actually open up and speak to anyone about this. So and like I said, as I referenced at the beginning, because there is this demographic shift that is going on, we're going to see more instances of this, more and more of it. We've obviously, in the last couple of years, actually, I mean, in 2020 was such a crazy year for everybody, not just because of COVID, but the racial reckoning as well, and really what sport organizations have gone through in really changing the way they show up, and the way they manage policy. But this is one of those instances where we have to have those bold conversations, those open conversations, and really take the time to understand different people's perspectives, because it is something that in all honesty, not everybody can relate to maltreatment in various forms, or they just have a different frame of reference that they're coming from.
I'm just monitoring the chat room, and a number of people have brought implementing a whistleblower policy, and perhaps this speaks a little bit to helping one's colleagues or peers out, being mindful of the environment, and where an individual is reluctant to come forward, perhaps assisting that individual. Now that opens up a whole can of worms if you're talking about whistleblower policy, and perhaps you can speak to that. I know certainly in the anti-doping code, they've just modified the whistleblower policy because it can be difficult being a whistleblower, not always accepted. And so one has to create the environment in which that is encouraged. Perhaps you can speak, Dasha, to the whistleblower aspect of this.
Sure. Yeah. So a couple of thoughts I had, and I actually think the whistleblower topic is sort of perfectly appropriate for what you were just asking, Bobby, Hillary, just because it is part and parcel of reporting. And it's interesting because I have some experience with whistleblower policies as they pertain to more corporate type environments where the whistleblower policy is really aimed to trigger complaints of regulations and standards not being met, fraud, things like that, things you really see at the sort of high end corporate level. But we've seen them more and more trickle down into basically, like, I don't even always call them whistleblower policies, they're more anonymous reporting mechanisms. And we see them more and more in organizations precisely to address the issue that reporting is a real problem. And oftentimes it's because the complaint mechanism or the complaint process in place, despite best intentions, has a very hard time breaking free of conflict of interest, especially when we'll use NSOs as example. If the complaint is being made against someone who they've hired or put in place, they again are put in that middle ground between the athlete and that staff person. So that's an obvious conflict of interest for the resolution of complaints. So hence the new semi-new requirement now to have a third-party reporting mechanism. And to me, in my experience, the big issue with whistleblower type policies is that they're a really good idea in theory. I find that organizations really struggle when an anonymous complaint is made as to whether they will actually pursue the investigation of that complaint, because a lot of the time it's anonymous because the person doesn't necessarily want to be identified, whether they're reporting on behalf of themselves or on behalf of somebody else. But then you don't have as much information to work with because you don't have an individual to pursue for more information and for an interview and an investigation. So you're often faced with a very difficult decision about, do I pursue this or do I not? So that to me is just one challenge I've seen, but I'm curious for Kate's comments as well in her experience.
Kate, perhaps you can chime in here.
I actually haven't done much with whistleblowing policies at all, but I have talked to a couple of athletes about complaints that they had considered making. And, one of them said, I don't want to make a complaint because, this individual literally holds my Olympic hopes and dreams in their hands. So it was a situation where they were weighing the pros, weighing the cons, weighing the risk to their career, and ultimately decided that they wanted to pursue their Olympic dream more than they wanted to pursue a complaint. So that's, I think, especially important or different in the sport context compared to employment context, where you do have a pretty limited time span for a career. Another person I spoke with didn't want to bring a complaint forward, but they felt a responsibility to young athletes to bring a complaint forward, despite the risk to them, they felt, because they wanted to protect other athletes. And the issue they also ran into was they felt that the whole institution was really set up to protect the employees rather than the athletes. So their challenge was, as much as anything, an attempt to change the status quo to help protect future young athletes from suffering the same, just, disrespect, not like sexualized maltreatment or anything, but just, wanting to keep people involved and passionate about sports, because they found that the treatment they received really negatively affected their desire to continue training and competing.
So the issue of privacy has come up repeatedly in a number of the panels, and certainly it is a concern, I think, for sport organizations, particularly in the employment situation. And it feeds into this anonymous complaint and dealing with, say, a dismissal situation and potentially facing a wrongful dismissal allegation. It's a very tricky minefield, and perhaps you can speak to that a little bit. Both Kate and Dasha work in the labor and employment areas. Do you want to start off, Dasha?
Sure, Hillary, sorry, and I just want to make sure I understand the question properly. So was it with respect to situations where a staff member may have to be dismissed, and just sort of the plethora of issues that come potentially, including wrongful dismissal in that situation? Is that, did I get you correctly?
Yes, and the privacy issues and the issue of an anonymous complaint coming forward, and you know, we know broadly that people are entitled to know the allegations brought against them, and so it becomes a little bit difficult when it is anonymous and when we're dealing with privacy issues. And I think sport organizations and the first panel talked about this, where an individual was charged criminally. And I think it's difficult for the sport organizations then to work in that environment where somebody is being charged criminally, and they might like to let their community know why somebody was let go, but they don't want to make it public.
Yeah, thanks very much for clarifying. I mean, in the case of a criminal charge, usually there's it's relatively public information. I mean, certainly the media focuses on some situations more than others, but if somebody has a criminal charge against them, all things being equal, even if it's at times hard to find that information, it's certainly publicly available information. So, and a lot of organizations, NSOs being among them, have policies whereby if somebody has a criminal charge being brought, and certainly a criminal conviction, that they would be placed on some kind of administrative leave pending the outcome of that situation, and it could constitute grounds for termination. And you're absolutely right. I mean, organizations will often let the criminal process play out in if for no other reason, then it does take a certain amount of resources to go through a civil or administrative process. So, and the criminal process obviously takes place without the parties sort of necessarily incurring expenses, at least on the prosecution side. So they want to see the result of that so that they can refer to it for their own decision making. But more generally, to your question about anonymous complaints and sort of the problems around that, I think it just speaks to the importance of thorough investigations. I mean, whether anonymous or otherwise, if you get a report, in almost no situation, unless the evidence in support of that complaint is just so overwhelmingly obvious that there's really not much to investigate, 99% of the time it's going to be much more nuanced, and it will warrant some kind of investigation. In the event of an anonymous complaint, the investigation might have to be that much broader, because rather than going to the single affected party or parties that they may have referenced, you're going to have to interview and investigate on a much broader level, including perhaps speaking to more individuals. Yes, that's onerous, absolutely. Is it necessary? Likely yes, especially if the complaint seems like it has merit and is substantiated to some extent. So investigations is the short answer, I think, to that question. From a privacy perspective, I think in any investigation, including within this kind of situation, you would want to maintain confidentiality and privacy to the utmost degree possible. I mean, you know, even under the Ontario health and safety legislation, like all other provinces, that is the standard that is required for workplace type investigations. And, you know, you're not to disclose sort of frivolously names of witnesses and things like that, but at times it does become necessary in the context of an interview to get proper information. So anyway, I hesitate to give sort of overwhelming concrete legal advice because each situation is so different, but suffice it to say that I think having the ability to investigate thoroughly is kind of the fundamental way in which you will avoid accusations that you have not followed due process especially in the event of a ultimate termination.
Thanks, Dasha. I think that commentary about the investigation really responds to one of the questions that's come up person was curious about situations that do not meet a criminal threshold. They still meet a legal threshold, legal standard, just perhaps a breach of an organization's code of conduct is a form of regulation, a legal form of regulation. And then, of course, we have civil standards as well. So I think only the most serious meet the criminal standard, but organizations, I think, become worried that they are, what standard are they dealing with and how do they recognize that? So what if we're dealing with a dismissal, but in a matter that doesn't really meet a criminal standard, not a standard of proof, but it's not a criminal matter? Then the organization is in a difficult situation in terms of privacy issues, in terms of dismissal issues, et cetera. So your comment around the investigation, I think, is a very pertinent one. That's where the information comes out and you can justify your actions.
Yeah, and most situations, Hillary, won't, in my, at least I'm subject to any disagreement that anybody wants to have in this situation. Like most situations won't meet the criminal standard. Very few will, and that's not just in sport, that's across the board. And you're absolutely right that even if it doesn't meet some kind of civil or criminal threshold, for example, Kate and I are lawyers subject to a code of professional conduct, and there can be discipline and consequences for us for breaching that code. Bobby, as a board member of Hockey Canada, will be subject to certain policies and a code, and that could have consequences for his board participation. I'm making us all sound really delinquent here, but but the point being that there are standards beyond the criminal and civil standard that are very much applicable with their own set of consequences, because regulation has to exist beyond those very sort of high environments where resolution is not immediate.
Thanks. It's a tricky area and very complex, and thinking about engaging this process at the provincial, territorial, and local levels will be challenging as we look at these complexities. I wanted to talk a little bit, and Bobby, I don't mean to leave you out at this point in time, but we're talking about the code at the moment. But the code is very helpful in terms of describing conduct that meets the description of maltreatment. But it also is a little bit vague, and it talks about volitional acts that result in potential for physical and psychological harm. So I wanted to ask you, Kate, around that from the organization's perspective in trying to identify conduct and deal with conduct that has potential. So it hasn't caused harm, but has potential. How do organizations deal with that?
Very carefully. I think it's a matter of having clear expectations for anyone who's going to be subject to that code, because people need to know what they might be doing that could breach the code. So it might be as simple as just putting in an example saying like, this could potentially cause harm, and if you repeat conduct of this nature, then that would be considered a breach of the code. But it is probably going to have to be relatively specific to the context. So I don't think you could just put in a blanket statement saying like, if you're cheering on the side of the playing field and you say, whatever words, that would breach the code of conduct. I think it would have to be a bit more tailored than that. But like the potential to cause harm is going to be significantly harder to try to, I guess, penalize if the code is breached based only on potential. If you look to doping, really the only way you potentially get in trouble for potentially doping would be if you have missed whereabouts or if you have an abnormality in your athlete biological passport. But it's harder to have something more tangible like that, like those examples carry over to, I think, maltreatment or potential maltreatment.
And it's made a little bit more tricky, isn't it? The panel yesterday talked about behavior being normalized so that we wouldn't see it as being, or some wouldn't see it as being out of the norm. It would be acceptable. And also we tend to trivialize single incidences quite often. And those are the ones that can escalate. So it's a very tricky minefield in that. We have a question around sanctioning, and I've been focusing a little bit on identifying the maltreatment in order to bring it forward for investigation, and that would be in the domain of the sport organization. But the thinking under the new mechanism is that the actual investigation and the hearing would happen through an independent party as well as sanctioning. And so the question is, beyond the issues that come up in pursuing an investigation, there's also the question of what sports organizations can say about a sanction it might impose and why it is imposing that sanction. Can you speak to this notion of a third party actually imposing a sanction? Dasha or Kate? Yeah.
Go ahead, Kate.
It's not unlike the court system. And I think in some cases, in terms of credibility, having a neutral third party impose a sanction according to the specific code of conduct or discipline policy or terms of reference is appropriate, because then it's not going to give the impression that there is bias in how the sanction was implemented.
I absolutely second that. Absolutely. And there's many different areas where exactly those checks and balances are built in to avoid a situation. So for example, municipalities, at least in Ontario, have pursuant to the Municipal Act, have an integrity commissioner that is in charge of a code of conduct, and they would make recommendations to a municipal council on any sanctions against, councillors. So that's one very specific example, and I won't lie, it's because I was dealing with that situation last night. So so that's why it's top of mind. But generally speaking, I fully support that thought. But also in addition, I think in terms of, if I'm reading the question correctly in the comments, I think what an organization can say about the sanction or why it's imposing a sanction beyond just them accepting the recommendation and going through with it, but making it somehow public that they have in fact agreed to pursue discipline, or why they may be terminating or parting ways with an individual. I think that automatically ties to a question that often comes up about any kind of central database that might exist of participants, whether it's coaches, other athletes, administrative professionals who have been sanctioned in any way or found to be in contravention of the code. If there can be some sort of database that allows anyone to access the fact that they have that kind of history. And it's riddled with, it's a very complicated question. And to be honest with you, I think that's why this version of the code, which admittedly is kind of the first attempt at harmonizing these concepts, doesn't go so far as to impose that kind of database, because it's still the considerations around privacy, jurisdiction as well, right? Because at the national level, you could have somebody sanctioned pursuant to the UCCMS, but can they coach provincially? And is there a problem of jurisdiction there? I think there's still a lot of issues to be ironed out, not to mention that there is an enormous amount of responsibility and liability associated with being the party or organization responsible for maintaining that database. Because if that's the case, then it should absolutely be accurate, because if someone's going to go there, not find a coach's name or an individual's name who in fact does have history, and you would presume that it's safe to include them in your organization, but later it's found out that that's not accurate, then that's a significant fault of that database. So there are other examples of this functioning, like the vulnerable sector checks that are performed when working with young people, and the fact that you have to go and that you might be part of a database that would prevent you from passing a vulnerable sector check. So there are absolutely instances where this functions, but I think we still have some issues to iron out before we can really see somebody take ownership of such a database. Just one more comment in terms of the specific question about publicizing any sort of sanction. I think to me, the best kind of defense, I guess, if you approach it that way, is truth. I mean, if an individual is being if an individual is departing for certain reasons, in the most severe cases where something like sexual abuse is identified, a lot of the time it's after the fact, and an organization is just going to be making a statement saying we're very troubled to have learned this. We kind of learned it for the first time as much as everybody else, and we're very disappointed and we support everybody, et cetera, et cetera. We've certainly seen a lot of that. If it's on more, call it amicable and early stages where perhaps there's been some boundary crossing, the organization identifies as problematic and chooses to ultimately part ways with that person, there's such a large spectrum, including in some cases, even confidential settlement agreements where an organization may potentially agree with that individual that, you'll go quietly and we won't publicize something like that, or we agree that, we'll mutually agree the way that we're going to communicate that information. Does that, I mean, I get a little worried even saying that, because does that attract risk of if that individual goes and, causes harm elsewhere, but that that's happened? And we've seen that pop up, right? We've seen that pop up in many sports, even across national boundaries, where a coach may surface, in the States, et cetera, and perpetrate the same behavior. So it's a very complicated complicated question. Now I'm just sort of rambling on, so I'll cut myself off.
Thanks, Nisha. And it is. It raises as well the issue of non-disclosure requirements. One of the situations raised during yesterday's panel, there in fact was, after the hearing, a requirement for individuals to sign a non-disclosure so that content of that particular complaint and how it was handled could not be made public even within the sport community. So it's a way really of stifling the conversations that today each of you have said is so important in terms of transparency and in terms of providing information to organizations. So it's a very difficult area. I want to pull Bobby in here just as he's having a sip of water. Bobby, just a situation that occurred the other year. A group of First Nations hockey players, teenagers, 13 to 14 years of age, were called savages and told to go home by spectators, and at least one of the coaches was involved in this. They were also subjected to opposing players mimicking stereotypical war cries and mocking the motion of a tomahawk. The tournament organizers said that the behavior was unfortunate and that it was deplorable, but insisted that there was little that they could do about it, either on the ice or in the stands. And basically nothing happened. And this certainly isn't a one-off incident. So what do we do with situations like this? And they really are fundamentally racist situations that are allowed to go unchecked.
Yeah, I think we all have a role to play in the elimination of racism. And sadly, organizations can't make comments like that anymore because the public is holding them accountable. And if I use professional sports as an example, the number of beyond sports even, but look at the number of teams that were held to account on their the namings of their sport organizations. I mean, I grew up watching the Edmonton Eskimos, and for the first time they've been rebranded to the Edmonton Elks, and that came because of, well, really it was the dollars from sponsors that started to speak. So I think it's no longer can organizations say that they don't have a role to play in this, or there's nothing else that they can do. I think organizations and individuals really need to take a stand and let people know what is acceptable behavior and what is not. And if you're silent, you're very much part of the problem as well. So I absolutely don't buy that anymore. It really comes down to, again, I think education and arming people, having a proactive approach in how to deal with these type of situations, but also what to do when these type of situations do arise. And let's be honest, I mean, the topic of racism is an uncomfortable one. It's nobody wakes up in the morning and is, you know, jazzed about talking about racism. It's a difficult conversation. So I think, you know, the more proactive organizations can be, this is within sport and even out of sport, the more proactive organizations can be about having, whether it's a policy or you know, whether it's a chain of communication when incidences like this do arise, the better off they will be, and they are then part of the solution to the challenge that we do have. I'm not sure if Dash or Kate have anything else to add to that as well.
Let me add on to that with a comment from yesterday, where the question was asked, in a situation where athletes have been asked to do something in a public space, asked by their sport organization to do something in a public space, and members of the crowd engage in cat whistling, who should do what? And in the course of this comment, there was some conversation that they should contact a bylaw officer, but that may not be the most effective way of dealing with this situation where the public is actually harassing and bullying members of the organization, athletes who have been asked to represent the sport organization in public. What's your perception of that? Kate, do you want to start?
Sure. Yeah, I think whoever organized the event is really the first point of contact for responsibility in terms of that. With that hockey tournament in particular, that one was very challenging to try to pinpoint, you know, if you were going to file a human rights complaint, where to go, because if I recall correctly, the tournament was like post-season, so it wasn't covered by the usual league rules. And then if you try to go to the actual rinks or the communities that own the rinks where the tournament took place, it was just like a very intricate game of hot potato in terms of how you could place responsibility. But generally, I would say that if you're organizing an event where athletes are being heckled, then the responsibility first falls on the organizer to either ensure that the audience acts appropriately or that they do have some mechanism to try to help protect athletes from that kind of heckling.
And would this rise to a legal responsibility, Kate?
I don't know. Probably not, based on where we are in society now. And I would hope that society is going to change in the right direction, where more and more people recognize this isn't acceptable behavior. And if that's the case, then it probably won't. But I don't know.
Could
Dasha,
I
do
add
you want
something,
to add
Hillary? Yeah, perfect. Thanks. I think, you know, it's interesting because there's always sort of the legal answer and there's the practical answer. Just again, a bit anecdotal, but a comparison that I keep circling in my head is charities, which actually a lot of NSOs are RCAAs, but charities have pretty stringent rules about what kind of activities they can engage in. So I had a couple charities around call it the peak moment during the last year of racial reckoning, as Bobby called it, which I will certainly use moving forward. Where charities asked me, can I post numbers of my local MPs and encourage our members to go and call them and, you know, encourage them to take action? Or can I post something on my social media that says Black Lives Matter, et cetera, et cetera, et cetera. And they were saying, are we going to get our charitable status taken away because we can't be seen to be lobbying or engage in political activities? And, you know, the legal answer is maybe I can go through those rules and give you my legal analysis of why that might be risky from a charitable purpose perspective. Practically speaking, I would really love to take on the case where somebody is going to go after your charitable status because you said Black Lives Matter. And that's just, you know, that's just the reality. I think this is a similar situation where even if you don't have some public code of conduct, I'm actually seeing more organizations have code of conducts for the public as well. So public attending events and associated, you know, privileges that could be lost if you do something like, you know, heckling or calling out. Pretty much anytime there's kind of a privilege afforded by virtue of membership or spectatorship or attendance, unless it's really kind of a wide open event or public where it's a kind of come and go, uncontrolled come and go, there are rights that could be taken away. And so a code of conduct can absolutely specify. I mean, we've seen this in the NBA recently, that spitting incident, the popcorn dumping incident, and those particular, if you can call them fans, those spectators had their season tickets revoked, and I believe a ban of attending games in the future. So there's definitely remedies. I think it's harder to enforce where perhaps, there's not a camera to capture those incidents. But increasingly, like Bobby said, it's taking a circle to hold those individuals and situations to the degree of accountability they deserve. And athletes have a huge part to play in that, because they have a platform in that moment, right, to call something out and insist not only that that specific individual or individuals are held accountable, but also that their respective organization supports them in whatever they want to see happen, including, if they stay silent, that they would like to see some action on their part or a statement on their part, etc. And I think we're in definitely a shifting moment in that respect.
The provisions that have been put in place and where we're at the national level, I don't know that it has changed the standard for organizations necessarily in terms of care of the athletes and ensuring a safe environment. I think it's brought it to light and emphasized what is necessary. But my question is this changing the standard of care for provincial, territorial, and local organizations? Is it raising the bar for them? And particularly for those that operate more on a volunteer basis. Kate, could you start there?
I think it is raising the standard of care. And just speaking from personal experience, I can say I've actually seen a little bit more action at the local level. And this would be like, I'm thinking specifically, I grew up in rural Nova Scotia, and involved in cross-country skiing, which is, not the most popular sport and not the most populous province. And the volunteers involved with cross-country skiing in Nova Scotia are extremely careful in terms of trying to make sure that they are abiding as much as possible with the national directions on safe sport. And that does introduce some difficulties, especially from a resource perspective, because we're talking about a small province. The provincial budget for cross-country skiing in Nova Scotia is something like $2,000. So it's a fairly big burden that's put on families who ski, who choose to compete. So when you have additional requirements in terms of like the rule of two, and you have one coach and one athlete in a certain region, it is hard. But I think the standard of care is changing, and I think there are at least some grassroots movements to support it. I'm seeing it maybe a bit less at the national level, but I also think the reckoning is significantly more public at the national level. And a recent example I think would be Rugby Canada, where you had the investigation into the head coach. Didn't find that the code of conduct was violated, but the head coach still stepped down, and Rugby Canada released a press release afterwards just saying that they need to make sure that their policies evolve as society evolves in terms of what is acceptable behavior or not.
Right. You raised the issue of the rule of two, and we've actually had quite a number of questions around that. The policy doesn't explicitly refer to it, but implicitly it does. And the question revolves around what about situations where you're dealing with adults, or you're dealing in some sports where one-on-one is necessary, or you're dealing with personal coaches and the athlete. Some sports have their partner as a coach. People are looking for guidance in how to apply that, because again, there is a standard that seems to be emerging, not a rule, but a standard that seems to be emerging. How do you respond to that rule of two, Dasha?
You're absolutely right. It's a common question. I've even in the early days of the UCCMS, I had people coming up to me at conferences saying, what about the rule of two? How are we going to handle it? It's impossible. And what if I'm caught having a conversation, simply a conversation with my athlete all of a sudden without thinking? And I mean, there's a couple of responses. Again, back to my earlier pendulum comment. I think sometimes when we create best practices to address very, very serious issues, sometimes those practices appear to be very onerous, and in some instances, not all, in some instances, even potentially overkill in order to address the issue in a particular situation. So, like I said earlier, in my opinion, sometimes the pendulum does have to overswing in order for the corrective measures to take effect, and then perhaps it can level out. Just like in a workplace, the best practice now is that in a situation where, for example, let's take a law firm, since it's salient to me, a senior partner is having a discussion with a student, particularly, particularly in that situation, they would leave the door open. It's just the best practice. It's very rare. Once in a while, somebody will be having a confidential conversation on a matter and they'll close the door. Is there a practical, balanced evening out that happens in those situations? Absolutely. Not every situation where a rule of two best practice is violated is going to lead to a contravention of the UCCMS, especially as it's currently drafted. Is it a best practice that the system is considering right now in order to address the very prevalent safe sport issues that we're having? 100%. And if it means that added effort has to be made in order to meet that best practice, then in my opinion, so be it. But legally speaking, I think that's why the UCCMS didn't go so far as to actually insist on the rule of two, because there is an acknowledgement within the code that sport differences exist. Sport discipline differences exist, and that there may be a situation where that's not practicable and just can't happen. That would be my response.
Thanks, Dasha. And in fact, an interesting comment just popped up in the chat line that the issue seems to be the word rule, and people interpret rule as mandatory or obligatory. And this comment was perhaps wording as such as best practice is better. I note that even in the code, it does talk about the flexibility, but it specifically talks about it with regard to field of play. But I think probably within the investigative phase, one looks at the context within which things are happening, and it's not a black and white kind of situation.
Sorry, Hillary, I agree with that comment. I think it's a best practice of two just doesn't have the same ring to it, though. So it's maybe good that more people are thinking that it is a rule than it's not. But of course, a rule is only as good as the mechanism that's going to enforce that rule and codify that rule. So right now, it's just an easy way for us to basically familiarize ourselves with a new and emerging best practice. But that's certainly true in terms of what it actually is.
Right. I'm going to switch gears just for a moment. And Kate, look to you on this one. Transgendered individuals, particularly transgender females, very often don't feel safe or heard in sport. And in the US, we're reading about a number of states that are passing legislation banning transgendered individuals from sport and from other aspects of society, in fact. Can you speak to this from a Canadian and human rights perspective within sport?
I generally think you have to take a values-based approach, and I honestly don't think that transgendered athletes should be prohibited from participating in sport. I think if you were to have a transgender category, that would kind of defeat the purpose of recognizing how someone identifies based on gender. So, when people complain about how it's not fair for a male to female transitioned athlete to participate in female sports, my answer is basically life isn't fair. And I don't think there's going to be any great influx of transitioned athletes competing. And I really, really doubt that anyone would transition purely for athletic reasons. I think it's just preposterous to suggest that. I think there's also a ton of contextual factors that make it really hard to apply a straight up ban, including, you know, how old someone is when they transition, if it's pre or post puberty. And just from another perspective, I also get very annoyed because I find it paternalistic, and I find it, you know, the concern is protecting female sport, but no one seems to care about the fact that, you know, someone born female can transition to male. There's not the same concern that the integrity of male sport is being affected. So I find the debate frustrating, and I just wish that it was over and that trans athletes could compete in the category in which they identify. The bigger challenge in terms of implementation is what to do with people who identify as, and I never get the term right, so I'm apologizing in advance, but if it's non-binary or gender fluid, like how do we accommodate those individuals in sport? Because I believe they have a place as well, and it's a lot harder to, when sport is kind of divided into two binary categories, it is harder to find space for that category, unfortunately. But generally, yes, I'm 100% in favor of trans inclusion.
Thanks, Kate. Anyone else like to comment? I think Kate made some really salient points there, good points, and open and continuing discussion is necessary, I think, particularly with regard to what's been happening with the laws being passed in the States. Yesterday, the panelists talked about moving to policies and processes in place to, and I like the way that the phrase that they used, to shut the door on people that you don't want involved in sport, the perpetrators of the behaviors of maltreatment, and we can all support that. But I was taken by a comment on racism in sport by a former athlete, and this is what he said: if you're a racist, you're not going to change because a club says it's wrong to be a racist. Ultimately, until we get rid of it, that is racism in society, it will exist in all walks of society. Bobby, can you comment on that statement? It sounds a bit daunting, frankly, for sport organizations. I don't know that it entirely is, but can you comment on that?
Yeah, I think one reality we have to accept is that we're not going to wake up one day and racism will be over. I think we're all collectively on a journey, and to shift perception, things take time. I think one way, again, that we can be deliberate and proactive about helping to eliminate racism is to create more positive experiences. And I think being more proactive about education and training is key. You know, a couple of questions ago, we were talking about, you know, grassroots efforts, regional, provincial efforts, and I wholeheartedly agree that what I've personally seen in the last couple of years is, you know, amid this racial reckoning, is, you know, some of the smallest organizations out there have become more attentive of, you know, what is happening out there and the role that they have to play to combating racism. They're not necessarily waiting, you know, for the national sport bodies to tell them what to do. They are taking matters in their own hands. I think, Kate, you know, you mentioned Nova Scotia. I've met with some fantastic organizations based in Nova Scotia. I've personally had the opportunity to travel, you know, to parts of Canada that I never thought I would, all in the name of diversity and inclusion. So I absolutely think that we all have a role to play in the elimination. I think it starts with education and awareness, and having those conversations. You know, I'm sure you saw a few weeks ago. I think it was the Serbian volleyball team, or the Serbian volleyball player that made an anti-Asian gesture towards the Thai team. You know, we don't want that happening with any of our Canadian national teams. It's not just a blemish on the player, the sport, or the team. It's a blemish on our country as well. So I think being more proactive in having these conversations, and making people more aware of our differences is one of the keys to getting and moving along that journey.
Thanks, Bobby. We're getting close to the end here, and I wanted to just get a couple of other things in here. This morning, Dr. Kidd talked about the challenge of bringing these national initiatives to provinces and territories and the local area, and that this was a very important element in the sustainability of this whole approach, effort, and initiative. What do each of you see as being some of the real challenges from a legal and inclusion perspective in doing this over the next year or so? Dasha, can we start with you?
Yeah, absolutely. I'm sorry to make you repeat yourself more than once, Hillary, but so with respect to just the implementation of the code at large,
the code, and we don't actually know what this independent mechanism is going to look like.
Right.
In fact, it's a little bit difficult even today to talk about some of the legal aspects, the code having just come into effect and the mechanism not known. But we do know, I think, that we can probably anticipate some of the broad strokes of it.
Yeah, absolutely. Thank you so much for clarifying. To me, something that I readily identify is buy-in and trust. I think that will be, especially given that the organizations that will likely, or the organization, I should say, that will likely be chosen to be the independent mechanism and administer the code is going to be an existing organization. And I don't know which one that's going to be, but each organization comes with a specific history and a specific past mandate. And so for there to be kind of a mental transition for those who are going to engage with it for the purposes of safe sport, I think there's going to have to be some very clear communication and some very good early examples of its effectiveness. And I don't mean, when I say effectiveness, I don't necessarily mean that they're going to hold someone accountable and prosecute them in the public, in the public square and all that. I just mean the process will be diligent. The person will feel heard. All parties will feel respected and like they've been afforded due process. I think there'll be a little bit of a test and a runway that happens. So I think buy-in, reputational management, and trust on behalf of athletes in particular, as the most impacted party by these issues, will be the first issues I see.
Okay, Kate.
It's very similar to what Dasha just suggested, I think, are the main challenges. And I think you can see the struggles that athletes have with the current system when you have some safe sport cases going through independent mechanisms, and then you have cases like artistic swimming with the launch or the application for a class action lawsuit against the organization there. And I think when you see athletes generally resorting to the civil law system, it's an indication that whatever process is in place isn't working, and there is going to need to be some pretty big steps to regain that trust that organizations are capable of handling these types of issues themselves without resorting to the judicial system.
Thanks, Kate. And Bobby, I should mention there was an interesting comment that came up in the chat line, and it said, should we be prioritizing a bottom-up versus a top-down approach? And that perhaps feeds into your perspective.
Yeah, I read that comment as well, and the parallel I'll draw, and really my day-to-day work with a lot of organizations, it's actually what's happening in the field, in the trenches, that organizations up here don't necessarily see. So I think it's a very valid point and suggestion to start in that direction. I think at the national level, though, the role that they can play there is actually to take some of the best practices and the learnings, and share them more broadly. you know, within the, you know, more of a regional basis as well. So I think it's definitely a great point. And I think in terms of putting the code into practice, you know, similar to my D&I comment, it's a continuous journey, and this is a starting point. And I think to Dasha's point about, you know, having examples of it in action and you know, showcasing the value of it, the reiteration and the continuous improvement, I think that's what's key as well here.
So I'm going to ask a blunt question then of you, and that is the entire process for sport organizations becoming too legalistic? Will sport have the capacity to engage in significantly and potentially complex matters that have been evolving, quite frankly? Again, Dasha, start with you.
Sure, yeah, and it's interesting because I think, you know, aside from, I think, the general excitement and recognition of the importance of the UCCMS and all the work that went into it, it's also been met with some slight criticism of the fact that it is a complicated document to digest still, and that it is difficult for some organizations to interpret and implement into their policies, which is the current requirement. So already in a document that's meant to be harmonizing and practical, we already see a little bit of that pushback. I think like anything that becomes regulated, like employment agreements are a great example of this, over time, I'm curious if Kate, you'll agree with me, over time, they seem to have become more documents about taking away rights and what you shouldn't do and what is not the case in the terms of your employment, as opposed to, hey, we're really excited to have you on board. Here's what we're providing you. We're really excited about this relationship. Here are some rules, you know, around and terms that are necessary, but overall, it kind of reads as like a, yes, I'm coming on board. Most employment agreements you pick up and you're like, you know, it's full of legalese, it's full of not permissive language, but quite the opposite. And that's because the employment relationship has just been so dragged out through the courts that all that language feels necessary in order to preserve whatever balances or boundaries need to be there in order for liability not to exist. So I really hope the same thing doesn't happen in this instance, where policies start to have so much language and legalese that they're impractical to read and impractical for anyone to interact with, because at the end of the day, they're meant to be a guiding document of the relationship between the parties. Athlete agreements have very similarly been scrutinized for that reason, that a lot of them that were floating around in the system before were just impossible to pick up and read, especially for, you know, a perhaps disadvantaged party from a sophistication perspective. So I think the challenge will be to keep the policies feeling readable while simultaneously incorporating some of these new concepts, especially in the early days while they're still settling.
Kate, your perspective on this?
I think if there is a clear process, that will go a long way in terms of helping mitigate perhaps the overly legalistic potential for this code. And I think if there is a clear process, you know, where you can set out maybe almost a universal terms of reference for how to do an investigation, that could ease the burden on some of the smaller organizations that might not otherwise be able to implement these. I think the biggest is, I think if you can get the NSOs and the PSOs aligned, it's much easier for the smaller organizations to fall in line. But when you have the gap between the NSO and the PSO, it is more challenging. And then you have the bigger issues with, you know, which process to follow, how to interpret the code, which, you know, what you're going to do with what provision.
And Bobby, from a non-lawyer's perspective, you have the final say on this question.
Yeah, I will say I am at a large disadvantage not having a law degree. I can tell you in participating in a lot of conversations. I'd say I'm relatively new to you know, sport on a national level. So I'm a little bit early in my journey there, but I can tell you that sometime I do wish I had a law degree so I could participate a little bit more. So I'll leave it at that for now.
Well, I think we've come to the end of our time, but I wanted to say, well, first, Bobby, I think that your perspective is actually a critical one in terms of recognizing that diversity is a characteristic of Canadian society and inclusion is our mission. And pardon me, dealing with that from a societal and a sport perspective is absolutely fundamental and paramount. And we heard that message actually in the other panels. So I think it's a critical perspective that we need to keep in mind and not be too myopic within the sport context. And thank you very much to all three of the panelists. I'm hearing a couple of very, very important things. One, that there are some legal issues that that will inevitably arise, and having some place to go for support, for advice, I think is going to be very important for sport organizations, not to feel alone in the wilderness, the legal wilderness. But equally important is creating space for conversations and for communication. We talked a lot about that today, but not about how to do that within the sport context. And I think that's a really important pathway to explore. So again, a tremendous thank you to the panelists. I think this has been particularly engaging and thought-provoking a session, and we truly appreciate that each of you has so generously shared your time and insights with us. And a small token of appreciation and reminder of your virtual visit to Niagara is on its way to you. And I see Mike there, so I probably don't need to say this, but this session has been recorded and it will be available to you. And there are discussion breakout rooms that you can let yourselves into, but I'll let Mike finish that up.
Thank you, Hillary. Just a big thanks to Dasha, Bobby, and Kate for your participation today. I think it's a very important conversation and how to operationalize a number of the elements that we have here, and in terms of making sure we're promoting diversity and inclusion throughout our organization and throughout our country. So thank you very much for the messages you shared with us today.